Okay, let's get into the nitty-gritty of character evidence under 404A when it's offered to show conformity therewith, when it's a pertinent character trait of the accused or victim, all right? In order to do this, we've got to look at Federal Rule of Evidence 404 and Federal Rule of Evidence 405. And there's literally a flow chart that I can go through. The first question that I ask myself, is it evidence of a character trait, other crime, wrong, or act? If it is, the next question that I ask, is character at issue in the trial? Now, what do I mean by that? I mean, is the offense or the defense that has been raised or the cause of action, if it's a civil trial, does it involve character as a core component? So, for example, a defamation case, character is a component of the case itself. So if it's an element of the offense, the defense, under 405, I can offer character any way I want on direct or cross-examination, and there is no limitation in the way in which I can admit the character, because I know that it is relevant to the proceedings. But most of the time, when I ask myself, is character a core component of the cause of action or the law that has been violated? The fact of the matter is it isn't. And that puts me into the much more narrow category of determining whether or not character evidence is admissible, and that's 404A1 and 404A2. Now, 404A1 deals with pertinent character traits of the accused, and 404A2 deals with pertinent character traits of the victim. I want you to think of it in this fashion. If it is character evidence is not involved in the cause of action or the crime that is contemplated. And the character trait is the character trait of the accused in a criminal trial. The only person who can reach out and put the key in the door and open character and make it relevant at the trial is the defense counsel. And the defense counsel can do this through cross-examination questions or by offering reputation or opinion testimony on the pertinent character trait through the testimony of a witness. That's how the defense counsel can open that door. When the defense counsel opens the door to the pertinent character trait of the accused by doing this, the prosecution now has the ability on rebuttal to offer evidence rebutting that character trait or establishing another character trait that is different from that one. And the prosecution has the ability to do that through reputation testimony, opinion testimony, or specific instances of conduct when cross-examining a witness as to the basis of their testimony. There is another door, 404A2, which is the character of the victim, because the defense could go after the character of the victim as opposed to the character of the defendant. When the defense opens the door to the character of the victim, they have now opened the door for the prosecution as well. And they can offer evidence of good character to rebut the negative character that's offered against the victim. But there's a neat thing that the federal rules of evidence do that not all state codes do in this regard. The federal rules of evidence were modified back in around 2000 to say that when you open the door to the character of the victim as to a particular character trait, you have also opened the door to the character of the accused as to that same character trait. That's a unique connection between 404A2 and 404A1 that exists within the federal law. And so the door to the character of the accused can be opened even though it's not the character trait of the accused, if it's the character trait of the victim instead. It's sort of a tit-for-tat type of rule. It's designed to ensure fairness in the application of character evidence at trial, and scholars have argued, quite frankly, over whether or not it truly creates that sense of fairness. But that's the idea behind it. Now, when you're understanding 404A1 and 404A2, to really get it, you've got to understand the form that the character evidence is admitted. And 405 gives us the form. That's the rule that gives us the form. And form is important for character. Because character is so overwhelmingly potentially prejudicial for an inappropriate reason, we control the format of the form. And the seminal case that really developed this structure and put it out there in a way that has been relied upon ever since is Mickelson v. United States. It's a case from the 1940s, and it's Supreme Court jurisprudence about character evidence. And it is one of the few cases that is mandatory reading when you're trying to learn evidentiary law. Mickelson v. U.S. is just something that anyone who studies evidentiary law should read and should understand. It's one of those cases. And they talk about the edifice of character evidence rules that have been designed to protect the accused and how the accused opens the door to character at their peril. But when the accused does open the door to character, there is still a specific structure to the presentation of the evidence. Initially, if you are going to bring up a character trait of the accused or victim through the testimony of another witness, the format that you must use is reputation and opinion testimony. They can talk about the reputation of the accused for that particular character trait within the community, or their personal opinion as to the accused character for that particular character trait. What they cannot do is go through the laundry list of specific instances of conduct that they relied upon in forming their opinion. That is not allowed on direct examination for the initial proffer of the reputation or opinion testimony. Why? Because it's the reputation or opinion testimony that the rule allows, not the specific instances of conduct. Because we're not arguing that the person acted in conformity with a particular prior instance. We're saying that they have a type of character that is pervasive. And this witness has an opinion as to that type of character. Now on cross-examination under 405, once opinion or reputation testimony has been accepted by the court, you as opposing counsel have the ability to test the validity of that opinion, the basis of it. One way that you can test the basis of that opinion is to challenge the witness who gave the opinion on what knowledge they relied upon in doing so. What does that mean? It means I start asking questions of specific instances of conduct that don't support the opinion that they just gave. And I ask the witness if they were aware of these other things. So let's say we've got a witness who just took the stand and they just testified on direct examination that they know the defendant, that the defendant is a peaceful, fun-loving individual. He volunteers at the nursing home. He walks little old ladies across the street. He works at the animal shelter. He goes to church every Sunday, and he raises money for the March of Dimes. He is on the roll for potential sainthood. So they say he's the most peaceful, loving person we've ever known. That's what they say on direct examination. Do you have an opinion as to the character of Mr. Smith for peacefulness? Yes, I do. He would not harm a fly. He is the most peaceful, kind human being that I have ever met. Maybe I know some things about Mr. Smith that aren't so peaceful and kind. I need to know if this witness knows it and relied upon it in forming their opinion. Ma'am, you just said that Mr. Smith is a peaceful, kind, loving individual. Yes, I did. Did you know that he beat his next-door neighbor with a baseball bat so badly that he broke his arm in 3 places? What's the witness say? Yes, I did, or no, I didn't, right? If she says, yes, I did, that calls into question the validity of her opinion, does it not? If she says, no, I didn't, that calls into question the basis of her opinion. Either way, I'm impeaching with these specific instances of conduct to attack whether or not the jury should accept her opinion on the character trait. I'm allowed to do this to test the strength of the opinion. But if I do, on redirect examination, opposing counsel is now allowed to go into those specific instances of conduct that did form the basis of the opinion that they were not initially allowed to go into when they first proffered the opinion. Why? Because I have attacked it through cross-examination. And by attacking it, I've made relevant these other instances of conduct where they would not otherwise be relevant. So if you'll think about it for a moment, at each step of the proceedings in the offering of reputation and opinion testimony, it is through the actions of counsel that we determine how broadly we go to get into specific instances of conduct. This means that counsel is making an intelligent, tactical decision at trial to potentially drag in the dirty laundry of the witness. And because the dirty laundry of the witness can really have consequences on the decision of the jury, we place the power to decide whether or not to make that relevant at trial in the hands of the defendant, because it's the defendant who's potentially going to lose their life or liberty. Let's move on now and look at 404B and how it connects to 404A.